Morning, council.
Good morning.
Judge. Morning, Your Honor.
Good morning, Judge Richardson.
Morning, Your Honor.
All right. We've got a few good cases to chew on this morning. So I think we've got 1, 2, 3, 4, which should be ready. Just let me make sure that we're ready to go on these. And I think I may excuse a couple of you for an hour or so that you don't have to stay connected and online while I deal with the first couple. So let me just go in order. Gerard versus Martin. Y'all are ready to go?
Yes, sir.
Yes, Your Honor.
Yes, Your Honor.
All right. Michelle Prescott versus Bell South.
A defendant is present and ready, Your Honor. I don't see opposing counsel here, and I have not heard from him this morning or since the court's order.
I wish I could say I was surprised at the tardiness of, of counsel, but I am not. We'll give him 15 minutes and see if he appears.
Thank you, Your Honor.
So I'm going to ask you to stay on.
Yes, sir.
All right. And next we have Allen versus AATC. Everybody's ready to go on that one.
Yep. Good morning, Your Honor. Austin Eiffel for AATC.
All right. And then Eggleston versus Eagle Custom Homes.
Morning, Your Honor. Colin Hatcher, we're ready to go.
All
Good
right.
morning, Your Honor. Adam Appel on behalf of the moving defendant. We're ready.
Good morning, Your Honor. David Rusnak, representing the co-defendants Weber and Taylor, ready to go.
All right. So what I'm going to do is I think at least in this initial hour from 10 to 11, although number 2 may be short. Folks here for Allen versus AATC and Agassiz versus Real Custom Homes. Check back in at 10:45. You're welcome to stay and listen if you want to, but you don't have to be on. I think these first 2 probably, they may not even take us a half hour, but y'all can sign off or blank your screen until 10:45, and then at 10:45, I'll turn to Allen versus AATC.
Thank you.
Good. Thanks, Your Honor.
Thank you,
Thank you,
Judge.
Your Honor.
All right, let's talk about Gerard versus Sally Martin. I have 2 motions for summary judgment. Let's talk about.
Excuse me, Judge. I do apologize. Give me 2 seconds. Sounds like someone has left the refrigerator open and I'm the only one here. Give me 2 seconds.
Sure.
Thank you.
All right, let's start with Mr. Hoffman's motion for summary judgment.
Good morning, Your Honor, and thank you, Valerie Morris, appearing on behalf of defendant Norman Hoffman. This is defendant's motion for summary judgment on the issue of negligence, Your Honor. There is no issue of material fact on the matter of negligence, and we believe that the court can rule as a matter of law on that issue. We are seeking dismissal of defendant Hoffman. This matter arises out of a multiple vehicle auto accident that occurred on the southbound 85 highway on May 3, 2019. I'm going to limit my discussion about what took place in the first two lanes. There were 4 lanes. The plaintiff was traveling in the number 1 or the fast lane. The defendant Hoffman was traveling in the lane to the right of that. We'll call that the number 2 lane if the fast lane is the number 1 lane. Traffic was beginning to slow in both lanes because up ahead, the drivers had noticed some metal in the roadway, and it was later learned that a truck had been traveling ahead of all of the slowing traffic and had dropped some roofing, or I'm sorry, siding, metal siding on the highway, and the vehicles began to slow. Mr. Gerard was traveling in the number 1 lane. He begins to slow down. The vehicle behind him does not slow down. He is rear-ended and struck, pushed out of control to the right into the lane where Mr. Hoffman was traveling. The testimony is that Mr. Hoffman had noticed the siding on the freeway or the highway as well and was slowing down. And when the plaintiff was pushed out of control into Mr. Hoffman's lane to the right, there was contact between the vehicles. Plaintiff contends that number 1, defendant Hoffman failed to slow down more than he was, failed to swerve or change lanes to avoid the accident. But there has been no evidence or testimony or affidavit or expert testifying or giving that information. It's just at this point speculation, and discovery is completed. I would like the court to look at the statement of material facts. Paragraph 10, plaintiff testified that he never saw what the defendant was doing in his vehicle at the moment of the collision or before the collision. Paragraph 11, plaintiff testified his vehicle went out of control and unexpectedly entered defendant Hoffman's lane. Paragraph 12, the plaintiff testified at his deposition there was no reason defendant Hoffman would have expected the plaintiff's vehicle to suddenly move into the center lane where he was traveling. And paragraph number 13, where we say the plaintiff testified in deposition that he was unaware of anything else the defendant did to cause or contribute to the accident. And Your Honor, on the issue of negligence, plaintiff has not shown a breach of duty. He's only speculated about what could have happened, coulda, woulda, shoulda. And there's no evidence to that. There's no testimony, there's no affidavit, there's no expert, there's no accident reconstructionist. And I think plaintiff's complaint and allegation fails on those issues. The person who rear-ended the plaintiff, that part of the case has been resolved, and that was the person who was at fault for the plaintiff's accident and the injuries by rear-ending him and pushing him into a different lane out of control. There was obviously a sudden emergency. Mr. Hoffman didn't know plaintiff was going to enter his lane. Plaintiff says he didn't know he was going to enter the lane. So without further evidence that defendant was speeding, had access to a lane he could move into, plaintiff's claims fail, Your Honor, against defendant Hoffman. And I would just cite OCGA 91156, Your Honor. The initial burden is on the party moving for summary judgment. After the movement has established a prima facie case, the burden shifts to the opposing party, who may no longer rest on the pleadings, but rather now point to specific facts showing there is a genuine issue for trial, a defendant may prevail on summary judgment without presenting any evidence by pointing to specific facts in the record or deficiencies in the plaintiff's complaint showing there is no genuine issue of material fact as to any of plaintiff's claims. And Your Honor, plaintiff had an opportunity to obtain affidavits from all of the other drivers. There were multiple drivers there, multiple witnesses who could say, if it was accurate or true, that there was something the defendant Hoffman did to cause or contribute to this accident. And there is nothing in the record to support that. And that's all I have, Your Honor.
Counsel, is there any evidence in the record as to how fast Mr. Hoffman was traveling at the time of the impact?
Your Honor, I believe the defendant testified that he was almost stopped. He was slowing down because he had noticed the metal, the debris in the roadway when he was struck by plaintiff's out of control vehicle.
All right, that is my only question. Let's hear from.
Yes, Judge. Paul Dietrich for the plaintiff. I'm sitting in for Richard Howe, who is on the pleadings. Good morning. This is we've always contended that this is a very simple issue. 3 vehicles in the left-hand lane spotted the obstruction and stopped safely. Mr. Hoffman, who was traveling behind this group and to the right, took this as it wasn't like super sudden, like where stuff fell off. You had to stop right away. His attitude was, this was not an emergency. Had he applied his brakes as though it were an emergency, he would have stopped. There never would have been impact, and our vehicle would have passed by him to the front. As it was, because he was still moving, as we moved into his lane, out of control, admittedly, we hit him on the front of his vehicle. Had he slowed sufficiently, he wouldn't have been in that position, taking this more serious than he did. And that's our position. And we think he's admitted that in the his deposition.
So, you know, I case law suggesting that a driver does not have the duty to anticipate cars suddenly entering their lane of travel. You're to keep a proper lookout ahead, but if cars are stopped in front of an obstruction and he is slowed down and there is no obstruction, there is no car or danger ahead of him, I'm struggling with the idea that the failure to stop in that instance is evidence of negligence. You've got a car suddenly launched across a lane of travel into the front of his car.
Mm-hmm.
And I'm having some difficulty with saying that his actions were objectively unreasonable, or that a jury could find that his actions in slowing down but not stopping could constitute negligence. Did he need to be clairvoyant and anticipate that a car was going to be
our position is we think even simpler than that. Of course, the law does require that where one reasonably should anticipate a collision, they have to avoid it, do whatever they can to avoid it. He was well behind a group of cars that safely came to a stop to avoid this issue. He admitted that he saw the same materials on the roadway, yet he didn't stop and collided with
one car safely stopped ahead of him
on the left-hand lane.
On the left-hand lane, why should he reasonably anticipate that one of those cars is going to suddenly be launched into his lane?
I think the point is he needed to have stopped because of the presence of the obstruction. Had he done so, the unanticipated launching would not have been, would have not occurred.
All right.
Everybody else saw this, everybody else stopped, except for the lady that struck us in the rear end.
All right. Anything else you wish for me to know?
Nothing else for the plaintiff, Your Honor.
All right. I think given the circumstances of the accident, the fact that folks were safely stopped in the lane immediately to Mr. Hoffman's left, that there was that Mr. Hoffman had slowed down in anticipation and seeing the hazard, and the fact that there was an unanticipated launching of plaintiff's car directly into his lane of travel. I think under the applicable case law, this is a circumstance that is proper for summary judgment. So I am going to grant Mr. Hoffman's motion for summary judgment. Ms. Morris, if you would prepare a draft order to that effect and send it to Mr. Townsend, copy, Mr. Dietrich, give you an opportunity to approve or object as to form, Mr. Dietrich, and then we'll get it entered.
Thank you, Your Honor.
Thank you.
I would like to stay on, if I may, to hear the results of the next motions. It's in the same case.
You are welcome to stay and observe.
Thank you, Your Honor.
All right, let's hear Mr. Woloski and Diaz Wholesale.
Good
Motion.
morning, Your Honor. My name is Casey Brown. I'm here for those defendants. I just want to add a few facts to the record. Ms. Morris did a good job of saying the basics. Mr. Wislowski was traveling in the first lane, the far right lane, around the time of this accident. As he was approaching the debris in the roadway, he was traveling 60 miles an hour, which is already 10 miles an hour below the speed limit. And the record from the parties' depositions is that actually other vehicles were passing him because he was traveling with such reasonable speed. There was no debris in his lane of travel, so there was no reason for him to slow down for the debris. As the parties have already discussed, Mr. Gerard was unexpectedly launched across 2 lanes of I-85 into the side of Mr. Wislowski's tractor. As Your Honor pointed out, case law makes clear that you have a duty to anticipate when someone is going to enter your lane of travel, not when there is someone that has come to a stop 3 lanes over for debris. So the case law on that is very clear. You've got a duty to look out in front of you. Something approaches from your side, you can't avoid it. There's no breach of that duty. Even if there was evidence of negligence in this case for Mr. Wislowski, there's no evidence that that negligence caused the accident. There's no evidence that if Mr. Wislowski had, braked sooner, driven slower, took a different action, that this accident would have been avoided. So there's no evidence of cause and fact. And to the point we've talked about before, there's also no proximate cause in this case. You've got a duty to see what is foreseeable to you, and having a vehicle that is 3 lanes over from you, rear-ended in such a way that is then launched across traffic into the side of your vehicle is not foreseeable. And so based on all of those issues, we would ask the court to grant our motion.
All right. Thank you, Mr. Brown. Mr. Dietrich, you want to respond to that?
Yes, sir. Thank you. The 18-wheeler situation is factually substantially different than all of the other drivers. This driver starts out 6 feet up in the air. He is looking above all of the traffic on I-85. He is not traveling at a high rate of speed, yet he has a clear view of the developments ahead of him and to the left. He is, by his own admission, between 100 and 150 yards away when he sees this disruption, the collisions occurring ahead of him. Within 300 to 450 feet is ample time and distance to either come to a stop or slow substantially and move into the right-hand emergency lane, which you can see from council's pictures is generously wide. Instead, he, quote, feathered his brakes, a light motion, as though he was just going to wait and see what happened. A simple, a heavier application of brakes well away from this collision scene would have prevented any potential harm to anyone. As it was, the impact, again, only occurred in the very front of his vehicle, which we can see from council's attached exhibit picture, Mr. Brown's picture. And again, slight slowing would have prevented this occurrence completely. As it was, the speed of his vehicle, that impact was so great as to reaccelerate the plaintiff back across 2 more lanes of traffic. This was a substantial impact, which we believe could have been avoided. 100 to 150 yards. You have plenty of time to stop, move over. That's what our position has been since the beginning, Judge.
So what do you, I assume you've read defendant's motion, and a couple of cases I thought were directly on point. The case of Eatman versus Weeks, which is at 320 Georgia Ave 578, and Johnson v. Ellis, 179 Georgia Ave 343. Have you looked at these cases, and do you have any contrary authority?
I don't have a direct response for that at this point. I will be happy within 3 days to provide any supplemental response that I can deem to be, what is today? Today's Thursday. I can have it to all council by Monday. To respond to direct, there were a number of cases cited in Mr. Brown's brief, very well written, by the way. And so I don't have a response to those 2 specific cases right now.
Yeah, I those are, I think, just examples of what I think is, the ultimate principle is the idea that you don't have a legal responsibility to anticipate traffic unexpectedly coming into your lane of travel. Now, would it have been perhaps safer for everybody involved if all cars and trucks had come to a complete stop upon seeing this material in the roadway? Perhaps it would have been, but this is not an issue of what is the safest thing to do, but what is reasonable under the circumstances. And based on the record I have here, there's no evidence in the record that that Mr. Woloski did anything objectively unreasonable in this case, and I just don't believe there's a jury question. So I'm going to grant the Woloski and Diaz Wholesale and Manufacturing Company's motion for summary judgment as well.
Thank you.
So,
Thank you, Your Honor.
So Mr. Brown, if you would, likewise, as I mentioned to Attorney Morris, prepare a proposed order, run it by Mr. Dietrich. He can object as to form, if he would, as to the form of the order, if he would like, and just get that to Mr. Townsend and we'll get it entered.
All right, sounds good. Thank you, Your Honor.
All right, thank you, counsel. You all are excused, although you're welcome to stay on if you wish to stay on.
Thank you.
Thank you, Your Honor.
Thank you.
Thank you, Judge.
All right. All right, Mr. Boyd,
Yes, sir.
thank you for waiting. Do we have plaintiff's counsel online? It is now 10:27. This hearing was noticed for 10 o'clock. All right, so what we had noticed today, and I actually wish we had noticed the motion for attorney's fees. We noticed plaintiff's motion for reconsideration.
Yes, sir.
That motion's denied.
Thank you.
We're going to set a hearing on your motion for attorney's fees.
Okay, thank you, Your Honor.
We don't have a date yet, but be prepared when we do set the hearing. Be prepared to, to testify as to have your folks testify as to amount. You may be subject to cross-examination. And we'll go from there. Just so the record is clear, and you can tell me if you disagree with any of this. On the motion, on the request for admissions, I believe this issue initially came to me on Bell South's motion for summary judgment.
Yes, sir.
The motion was based in large part on a request for admissions being deemed admitted because they had not been timely responded to or objected to. At the hearing on that motion, I noted that they were subject to admission and that there had been no motion to withdraw admissions by the time of the hearing, which occurred sometime even after your motion, and you had pointed out the admissions. Nevertheless, I agreed to allow plaintiff's counsel the courtesy of making a late motion to withdraw those admissions, but I established a fairly firm deadline. And I also advised that really in exchange for being afforded that courtesy, he would be responsible, plaintiff's counsel would be responsible for your attorney's fees incurred in filing the motion for summary judgment. He did not file his motion to withdraw admissions in a timely manner, and as established in your motion, responding to his motion for reconsideration and his objection to attorney's fees, you noted that he had refused to pay any of the attorney's fees for summary judgment unless I issued an order. So we're going to have an order. We're going to have a hearing on your motion for attorney's fees, and there's going to be an order. I think I have already ordered that he's responsible for the reasonable fees incurred on the motion for summary judgment, but additional fees will be in play on this on the motion that you filed. So we will set a date for that. We'll give you notice of that, and we'll see if plaintiff's counsel attends that hearing.
Thank you very much, Your Honor. First, I'd like to say that was all very succinctly and accurately put, and we appreciate the court's time, and we'll be on the lookout for that notice of hearing.
All right.
Thank you,
Thank
sir.
Boyd,
May I be excused?
excused.
Thank you, sir.
All right. I said next folks to check in at 10:45. I don't know if we still have, if we have all the parties here for Allen versus AATC. If they're still on and ready to go.
It's me and Mr. Hiffa. I'll email him too. It looks like he is still on, not having his camera up, but let me see if I can prompt him.
And Judge, hi, this is Elliot Ream from Hawkins Parnell. I'm covering for Brian Grantham. We represent a co-defendant all in one security, but it is AATC's motion.
All right, so I think Is that everybody, or are we still missing somebody?
Mr. Hiffa.
Mr. Hiff.
Yeah. Well, there is another attorney judge.
Oh, and that, yeah.
Copeland Stairs on this case, but the only motion today is between myself and Mr. Hiffa. So the other folks are just here.
All right, since the principals are here and since I'm streaming this hearing on YouTube, it will be available for folks who can't resist the urge to go back and see a replay. Let's go ahead and get started on AATC's motion.
Okay, good morning, Your Honor. Austin Haifa for AATC. As Your Honor may recall, the court has previously heard oral argument on the defendant security company's motions for summary judgment. And during that hearing, the parties discussed in great detail the underlying facts of the case. So I imagine Your Honor has a pretty good understanding of what transpired at the airport. So unless the court prefers otherwise, I'll be very brief with respect to my recitation of the facts. Put simply, this is a trip and fall case. This is a trip and fall case at the airport on January 9th, 2019. Mr. David Allen was attempting to catch a flight to Milwaukee, Wisconsin. The flight was departing out of Concourse C. He goes through security, gets on the plane train, exits the plane train, and as he gets off the escalator to go to Concourse C, he takes a rather unconventional approach towards his gate. He cuts around the corner, and a few steps later, he trips over a stack of rubber floor mats that were located either abutting the concourse wall or near the concourse wall. Ultimately, the plaintiff falls and injures himself. And that really, in a nutshell, is the facts of this case. At the hearing on the security company's motion for summary judgment, Your Honor heard extensive argument as to the issue of who is responsible for the mats, who placed the mats, who moves the mats, who controls the mats. Plaintiff presented evidence in the form of testimony and photographs showing that the security companies are the ones who stand on the mats. They use the mats for standing posts throughout the concourse, that they're the ones responsible for moving and placing the mats, and ultimately that they're the ones responsible for stacking the mats and creating the alleged hazard. On the other hand, the security companies argued that they were not the ones responsible and tended to allege that the janitorial company, ABM Aviation, were the ones responsible for moving and placing the mats. And the reason I say this is I find it important to note that plaintiffs are not contending, and neither do the security companies for that matter, that AATC has anything to do with the mats at issue. They don't own the mats, they don't control the mats, they don't move them, they don't place them. In fact, they're not even allowed to touch the mats. And after nearly 30 discovery depositions that were taken throughout the course of discovery, not a single deponent testified or even otherwise suggested that AATC has anything to do with the mats. So the issue in this motion for summary judgment is not about who is responsible for creating the hazard, but this is more of a traditional premises liability theory, and that the plaintiff is alleging that AATC is an owner or occupier of the premises such that we have a non-delegable duty to keep the premises safe and free of hazards. AATC certainly acknowledges that owners and occupiers of a premises do have a non-delegable duty, but AATC disputes that it's an occupier of the premises or an owner of the premises. It's undisputed that the airport is owned by the City of Atlanta and is operated by the City of Atlanta's Department of Aviation. But the plaintiff did not name the City of Atlanta as a party defendant in this case. So the real issue is the issue of occupancy. As Your Honor knows, the City of Atlanta contracts with numerous different entities to lease portions of the airport, to operate portions of the airport, to secure the airport. And the area where plaintiff fell on Concourse C is part of what's known as the Central Passenger Terminal Complex, or the CPTC. The CPTC is leased by the 6 major airlines who occupy the airport. That's Delta, United, American, the 6 major airlines. These airlines collectively are known as the signatory airlines, and they jointly lease the CPTC pursuant to 6 separate but identical lease agreements with the City of Atlanta. The signatory airlines are the occupiers of the airport or of the CPTC, and they're collectively responsible for maintaining and operating the CPTC. And pursuant to their lease agreements, they're responsible for all the systems and components in the CPTC, for keeping the CPTC functional, for keeping it safe, for keeping it clean. However, like the city of Atlanta, the plaintiff didn't name the signatory airlines, the legal occupiers of the CPTC, as a party defendant in this case. And instead, they named AATC. And AATC is a maintenance and operations company that was formed by the signatory airlines for the purpose of helping its members fulfill some of their obligations with respect to the CPTC. But AATC is an independent contractor of the airlines. Does AATC have certain obligations with respect to the CPTC? Absolutely. We don't dispute that. AATC performs daily inspections of the concourses. They hire third-party vendors to perform certain functions at the airport, such as cleaning, such as doing repair work, and they investigate certain incidents that happen at the airport. But is AATC responsible for everything that happens at the airport? I would say no. And does AATC exercise complete control over the CPTC such that they're deemed an occupier of the area? I would say no. In fact, there's several.
That's where I have some trouble with the argument, because I hear you saying, well, yeah, we're responsible for some things, but we're not responsible for some other things. And then I've got, in the record, some things that plaintiff's counsel, Mr. Stoddard, has put in the record, where there seems to be admissions and there seems to be documents that say.
Well, if I could address those admissions. So plaintiff has taken the language from AATC's contract with the signatory airlines, which states the purpose of AATC is to help the signatory airlines fulfill their obligations under the lease. And seemingly conflating.
Excuse me, Mr. Hiffer, could you slow down just a little bit?
Yes, ma'am, I'm sorry.
Thank you.
So the agreement with AATC, its operating agreement, states their obligation is their responsibility is to help fulfill the obligations with respect to the CPTC. But it appears that the plaintiff is conflating this to mean that AATC has assumed the role of the lessee, or that the signatory airlines have somehow surrendered complete possession and control of the CPTC to AATC. And this is
given whether they have sufficient possession and control, isn't that a jury issue? I mean, especially if you've got conflicting things in the record. I mean, I understand your explanation, and I can say it's a sensible explanation, but in the end, it's an explanation that requires a finder of fact to resolve. Isn't that correct?
I would agree that the issue of occupancy is generally an issue that can be determined by the jury. But what I would argue is that if Your Honor determines that there are issues of fact as to whether or not AATC occupies the premises, I would argue that occupancy or that control over the premises needs to be limited to the aspects of the CPTC that they actually control, or that they actually have authority to oversee. In this particular case, it's already been established that AATC does not have anything to do with the mats. They're not allowed to touch the mats. So even to the extent that they have control or possession over the CPTC, there are certain aspects of the CPTC that are outside the realm of their authority.
But
for example, and
safety generally, though, is within the purview, right? Even if it doesn't mention mats, or even if it didn't mention water specifically on a floor, or even if it didn't mention a hole somewhere in the floor, if the responsibility is safety generally, there's at least a factual argument that the mats are encompassed in that, isn't it?
Yes, and I would agree that generally speaking, AATC's part of its obligations is to ensure safety. But I guess the argument that I'm trying to make is that there are certain things that AATC can't control because it's outside of their authority. For example, the mats. If you take, for example, let's say the security system, the security camera system in the concourses. Yes, those are a part of the CPTC. But if, for example, a security camera fell from the sky and hit a passenger on the head and caused injuries, then it's outside the scope of what AATC can do to maintain safety in the airport, because they're not allowed to touch those security cameras. They're not allowed to maintain them. They're not allowed to move them. So if it falls, it's there's really nothing that AATC can do about it. In the same sense that if the stacked mats at issue are not the mats of AATC, they're not owned by AATC, they're not allowed to touch them, they don't control them. So it's really the entities that control the mats or have the ability to move the mats that would be responsible for the hazard at issue. And we submit that AATC did not have the ability to move the mats or control the mats.
Did your AATC contract with for janitorial, the company that is alleged to have moved the mats?
AATC does contract with ABM Aviation, who is the janitorial company on Concourse C.
So maybe you don't have control or authority, but if your agent or someone under your authority moves them, even without authority to do that, wouldn't that be imputed to AATC?
Yes, and so we agree with the general notion that the knowledge or authority can be imputed via an independent contractor, but we would argue that there isn't sufficient evidence to show that ABM were the ones who moved the mats. And again, the idea that it can be imputed to AATC rests on the notion of the line of cases that call for the imputing of liability rests on the notion that the entity that it's being imputed to is either an owner or an occupier of the premises, and we dispute that we occupy the premises.
All right. I'm gonna stop giving you a hard time through the rest of your argument, but
no, I understand, Your Honor. I understand that I have an uphill battle there. So the last thing I want to address in terms of the issue of occupying the premises in plaintiff's response in opposition to our motion for summary judgment, plaintiff points out that there are 2 affidavits that were previously submitted in trip and fall cases at the airport that somehow admit that AATC is an occupier of the premises. I've reviewed these affidavits, I've gone through them at great length, and just want to point out that I don't see anything in these affidavits that even remotely suggest an admission that AATC is an occupier of the premises, and I don't believe that statements made in a prior case that's completely unrelated to the case at bar have any bearing on the issues in this case. But I'll move on from the issue of occupancy, and I want to talk about the hazard itself and AATC's purported knowledge of the hazard. AATC disputes that the mats themselves created a hazardous condition or that AATC had any knowledge of the hazardous condition. With respect to the hazard itself, there's one eyewitness to the accident, Mr. Taylor Place. He was a pilot in the airport. He saw the fall happen. He testified unequivocally that from his vantage point, he was able to see the mats, that he didn't think that it was necessarily a trip hazard or something that the plaintiff could have seen, or something that the plaintiff shouldn't have seen. And moreover, under premises liability, the plaintiff needs to demonstrate that the alleged hazard presents an unreasonable and unexpected risk of harm to the plaintiff. I don't believe plaintiffs have satisfied this burden in demonstrating that floor mats on the floor are unreasonable or unexpected. And I would submit to you, Your Honor, that where else would you expect to find floor mats if not on the floor? But even if, Your Honor, were to find issues with respect to whether the floor mats constitute a hazardous condition, there's absolutely no evidence in this case to suggest that AATC had actual or constructive knowledge of the hazard. There's no evidence that any employee or representative of AATC ever saw the mats on the day of the incident. There's no evidence that they've ever seen stacked mats anywhere on the concourse ever. There's no evidence that AATC was in the immediate vicinity of the hazard. There's no evidence that AATC failed to exercise reasonable inspection of the premises. In fact, the evidence shows that AATC did have reasonable inspection procedures in place, and they carried out these procedures on the day of the incident. And moreover, to establish constructive knowledge for failure to exercise reasonable care in inspecting the premises, the plaintiff is required to prove the length of time that the dangerous condition was allowed to exist on the premises. And plaintiff cannot establish this. Nobody can establish this. And plaintiff has never stated with any particularity the amount of time that the hazard remained on the premises. And lastly, as to knowledge of the hazard, no employee or representative of AATC has ever been aware of any similar prior mat-related incidents that are substantially similar to the incident at bar. In plaintiff's opposition to our motion for summary judgment, plaintiff cites to cites to a prior incident, and we've poured through the incident reports, hundreds, if not thousands of incident reports, and we've turned them all over to plaintiff's counsel. And plaintiff points to one in particular, one incident that happened 3 days prior to Mr. Allen's fall. However, the incident that plaintiff points out is completely distinguishable from the incident that happened to Mr. Allen. That particular incident, the one that happened 3 days before the accident, involved an American Airlines employee who slipped, not tripped on a mat, and it was a single black mat, and it was located near the exterior door of the American Airlines office. AATC has nothing to do with this area of the airport. This incident involves an American Airlines employee and not an airport passenger. And it was reported the reason for the slip was because the mat was wet and slippery because there was nearby pressure washing outside. And there's no evidence that this incident even involved the same type of mats that the plaintiff tripped over. So we find this incident that plaintiff cites to be completely distinguishable and irrelevant to the subject case, and we find no reason for this one incident to impute knowledge to AATC as to the issue of stacked mats. And lastly, Your Honor, my final point that I'll talk about, and I don't believe that this was addressed in the defendant security company's motion for summary judgment, is the issue of punitive damages and attorney's fees. There's absolutely nothing in this case that would give rise to punitive damages on the part of AATC or attorney's fees. There's no evidence whatsoever that shows that AATC acted willfully, intentionally, wantonly, or acted with any bad faith. And there's certainly no clear and convincing evidence that AATC acted with this requisite conduct. Your Honor, I would submit to you that nothing in this case is clear and convincing. And there's certainly a bona fide dispute as to liability with respect to attorney's fees under 13-611. The last thing I'll say is that in plaintiff's brief in opposition to our motion for summary judgment, plaintiff makes an argument that because AATC has not chosen to make a separate case for summary judgment as to punitive damages and attorney's fees, that this court should not do so on his own. And in support of this argument, he cites the Pfeiffer versus Georgia DOT case. I've taken a look at this case, and that case stands for the proposition that issues cannot be raised for the first time on appeal if they haven't been previously raised on summary judgment. The case is not relevant to the case at bar. AATC has raised the issue of punitive damages and attorney's fees in its motion for summary judgment. I'm not aware of any case law that would suggest that these claims would need to be brought in a separate motion. These claims are properly before the court and are ripe for the court's consideration. And Your Honor, I understand that there is an uphill battle with respect to liability on the part of AATC, but I would say that if anything is clear in this case, it's that there are no grounds for attorney's fees or punitive damages. There's just simply no evidence, and certainly not clear convincing evidence.
I certainly agree with you that this is your best argument is on attorney's fees.
I appreciate that. And Your Honor, I'll close. I'll close with that, and I appreciate the court's time and consideration. And we ask that you grant summary judgment in favor of AATC.
All right. Thank you, Mr. Hiffa. All right, Mr. Stoddard.
Well, so first, Judge, there were a number of liberties taken there with some facts and some law too. And, Mr. Hiffa, I don't remember if he was in the case at the beginning or if he came in later. There were many depositions he didn't attend, so I'm not saying it was done intentionally, but just to clear up the record on one or two things. Oops, it looks like, can my screen sharing be enabled? I wanted to show the court some things.
Yes, give me a moment. All right, you should be able to share now.
Thank you. So the first thing I wanted to show was this is Plaintiff's Exhibit 20. You heard Mr. Hiffa say that AATC has nothing to do with the maps. Well, this is an internal document that was produced by AATC. The mats are supplied by AATC. And this was a deposition exhibit too. So that is just not accurate. The next thing that I wanted to say was really took me by surprise was an argument by Mr. Hiffa that the signatory airlines are responsible for the airport. That is the first time, today is the first day that we've ever heard them say that. And in fact, we didn't even know about the signatory airlines until after the statute of limitations ran. And if you look at the defendant's discovery responses, We asked them specifically about who owned and operated the airport, and their response was that the city owns it and that AATC is responsible for facility maintenance. No one ever identified any sort of signatory airline. The question was, who owns, operates, manages, and maintains the airport? And their answer was, the city owns it, we do facility maintenance, until after the statute of limitations runs. Then we start hearing about signatory airlines. So it sounded like Your Honor was kind of leaning our way on a number of issues anyway. And so I encourage you to step in and tell me, Mr. Stoddard, you don't need to tell me any more about that issue.
I think in terms of ownership and control, I think I've signaled pretty strongly that's a jury.
Okay.
That's a jury question, so you don't have to argue that. Frankly, the existence of a hazard and knowledge of a hazard, I think I have already addressed those on prior motions for summary judgment by some of the co-defendants. So you don't need to readdress those issues of whether there is a hazard and whether there is equal knowledge. I think you've addressed those on oral argument before, and I have ruled in your favor on those issues before.
Agreed. On the it's a hazard issue, I will point out that this particular defendant's own employees admitted it was a hazard. Mr. Bertram was the operations manager at the time. He said it's a hazard. This is Mr. Morrison, worked at the airport for 23 years, came out to check on this incident. He said it was a hazard. Mr. Smith, I believe he's the head janitorial guy. He said it's also a hazard. So that seems to talk about that issue. The defendant's knowledge, do you need to hear any more about that?
I don't. I believe you've got an agent. There's some evidence in the record that their agent moved the mats. I know it's disputed, but it's a disputed fact, but it's their agent, and there's an issue of fact as to whether their agent moved it.
Perfect. Okay, so we're with you on all of those things. And that just takes us really down to the plaintiff's lack of knowledge. So we kind of talked about that already too. You happy there, Judge?
We have talked about it. I think whether plaintiff should have seen it, could have seen it, could have avoided it. I think under the circumstances, it's a question of fact. You don't have to argue that.
Great. And I'll add, by the way, that to my memory, Taylor Place, this American Airlines pilot, did not say that, it was the sort of thing that the plaintiff should have seen or not tripped over. I don't believe that's accurate. And also he had a very different vantage point. He wasn't coming around a corner. But in any case, we'll just move on to the last issue, which it sounds like is the one you wanted to hear about, which is the conscious indifference, bad faith, stubborn litigiousness, unnecessary trouble and expense.
So let me ask you this question first.
Sure.
In almost every premises liability case, right? Well, not almost every, but so many of them, the issue is, was there a known risk? And did you take some effort to mitigate or eliminate that risk? And almost every case requires that there be some notice on the part of the defendant. So what distinguishes this case from any other premises liability case where you're like, oh, those mats are a risk because somebody tripped over them and it happened again? That's the basis for negligence. How does that also become the basis for punitive damages? It seemed like you would have punitives available in every case under that theory.
Actual knowledge would be the difference. So in this case, if the jury believes that the janitorial staff is the one that stacks the mats, then it's not a constructive knowledge issue. It's not about, oh, well, there was water on the floor. We didn't see it, but maybe we should have. We recognize sometimes water's on the floor. It is, we created the hazard. So when you create the hazard as a company and you're also aware that it is a hazard and that someone else has been hurt, then that's conscious of a problem and indifference to the consequences. And so that's the difference. And that's the punitive damages standard. It's not a part that Mr. Hiffa mentioned, but that is what it says under punitive. If you're conscious of a problem and then indifferent to the consequences. And then he talked about the evidentiary burden as being not more likely than not, but clear and convincing. But if you're weighing how much evidence there is, then you're substituting your opinions for the role of the jury. So it's the jury's role to determine if there's clear and convincing evidence. If there's evidence, then it's not a summary judgment issue. But I don't think that really matters today, to be honest, because there is evidence. I mean, there is evidence from like 5 or 6 witnesses. I passed through it, but I can go back and show you. There's like 5 or 6 witnesses that are like the janitorial staff stacks the mats. They do it sometimes. It's their custom and practice to move them and clean them. And so the jury can say, well, this janitor stacked them and put them there. And also there's evidence that the company knew that this is a hazard that people can fall over. So you put those two together and the jury can say, well, they're conscious that it's an issue and they're indifferent to it, not because they were trying to guard for it. They actually created the hazard. And so that's how you get there on punitive and bad faith attorney's fees. Now, there's another way to get to attorney's fees against this defendant, which is the stubborn litigiousness, unnecessary trouble and expense track. So let me talk to you a little bit about that. That's not a punitive damages issue. The case law says punitives and bad faith attorney's fees are essentially the same standard until our Supreme Court clarifies it. And honestly, I think they should, because they're not the same words. But the current binding case law that you're supposed to follow says that the evidence that authorizes punitive damages authorizes bad faith attorney's fees. There is this other issue, though, of the conscious indifference and unnecessary trouble and expense. And so let me talk about that as it relates to this defendant. And it actually shoehorns in to another motion that's pending. I don't know if we're going to hear that today, but there's a motion for protective order that AATC filed as well. And so it's a failure to preserve video. And so let me talk about that. So this fall happened on January 9th. And as you can see right here, this is Mr. Allen right here. But as you can see right here, there's a video camera. And there's some other pictures that show there were actually multiple cameras that were in this area. This is Mr. Campbell. He is in charge of a $500 million AIG insurance policy that was purchased. I don't know if the city pays for it or AATC pays for it, but they're joint insurance under the policy. Mr. Campbell kind of runs point for anytime someone gets hurt at the airport. And he also kind of helps set policy. He'll say things and you'll see some emails where he says, look, someone fell on a mat. Y'all need to move the mats. That's the insurance guy. He's the only one that seems to care. But anyway, Mr. Allen fell on 1/9, 2019, not 2020. And he's telling the Allens, Mr. Allen at the scene asked about insurance. And so that prompts that duty to investigate. But Mr. Campbell emails him a few days later and says, I represent you guys. If you want to make a med pay claim, because there's like a $5,000 or $10,000 med pay policy, you got to do it within a year. And then also Mr. Campbell says, you need to preserve video footage. And he tells that to Mr. Bertram, who works for AATC, the operations manager. He says that on the 17th. Fall was on the 9th. And so Mr. Bertram contacts Rohan Stewart, who works for Atlanta, who's in charge of the video footage, and says, I have another request for video. And so he does that on the 17th. At the same time, on January 29th, so within this 30-day period, it's a 30-day retention on the video. I'll show you that in a minute. You'll have the plaintiffs have a lawyer out in California at that time, emailed Barry Campbell and also asked about the case. So, they're clearly on notice within the 30-day period that there's going to be a claim. You got insurance communication with the Allens, with their lawyers, and you got insurance saying, go start investigating and get some information. This is Mr. Stewart, and he's saying it's a 30-day retention time. So within that 30-day period, they knew to go get the footage. It would basically answer, 99% of the questions in this case. And apparently the insurance company does that a lot, according to Mr. Stewart. They go request the video footage. Now, I'll come back to this. In this case, we don't have any video footage. Nobody's got any answer for that. Originally, we didn't have a lot of the emails I just showed you. I had to go back to, and I'm not blaming Mr. Hiffa or Mr. Hooray, who represent AATC. And as soon as we started trying to get information from the city, he represents them too. And it took many, many months and me going back and saying, this isn't everything, me deposing multiple people at the city. And all of a sudden, all these emails pop up about we're requesting video. Where's our video? Well, if you're on notice of a claim and you start investigating, and this is what it says in Baxley and Walters v. Kroger, then you have a duty to preserve the evidence. You have a duty to maintain and not destroy evidence, but also to preserve what's out there. And in this case, AATC, well, they took photographs, they took witness statements. And by the way, the photographs they took, we found earlier photographs that are more helpful to the plaintiff. So they got the good stuff for the defendants, good statements, good photographs. They can go get this video. Mr. Rohan, who works for the city, says, yeah, they can get a copy of it. They can also come by and look at it. No explanation. We deposed all these people. Nobody remembers these emails. Nobody can tell us what happened to this video. Well, in Walters v. Kroger, there was a somewhat similar incident at a Kroger. In that case, and I'll show some of it in a minute here. I'll go ahead and show it to you now.
Before we go any farther down this path,
Yes,
are
sir.
you suggesting that this evidence of potential or alleged spoliation is in support of a claim for stubborn litigiousness?
That is exactly what Walters v. Kroger says, Your Honor.
Okay.
It says that had they maintained this video, it would have showed what happened. And now the plaintiff has to prove what happened. And that 13-611 says stubborn litigiousness and bringing the plaintiff through unnecessary trouble and expense.
So here's the I guess the hesitation I have with that. I don't see any dispute as to what happened that incident. And if there was video to be preserved, it would be of that incident. What really seems to be the rub here is who moved those mats?
Well, I have two responses to that, Your Honor. First, I would disagree with you a little bit, but let's move to the second part about who moved the mats. Well, that's on the video too. The video shows if it's around, they can preserve it for 30 days. They can wind it back and show who set those mats right there. Was it the janitor? Was it the security staff? And we can solve that question. Secondly, if we had the video, we could know, was Mr. Allen walking with due care, looking where he was going? It's additional evidence to support those parts that we didn't do anything wrong. So it would answer both of those questions. And their failure to preserve it screwed up the case. And what Walters v. Kroger says is when that happens, you've now brought the plaintiff through unnecessary trouble and expense such that the jury could determine to award attorney's fees. 13-611 typically talks about stuff that happened before you file the suit. And that's what this would be, because you spoiled the evidence before the suit's filed. There's 911-68E, which is the other way to get attorney's fees. That talks about your post-filing conduct. So were you a jerk, basically, once we filed the complaint? But this is about before we filed, did you do stuff that brought us through unnecessary trouble and expense? And when you're not preserving the video, which creates the whole question, you've done that. And I'll tell you, they want that. They should have got that video if it helped them, because it's what they do. There's contracts with all of these providers, right? As soon as the AATC finds out that it's some janitorial staff, or if it's security, they try to push it out to them under the indemnity contracts and say, your insurance policy needs to cover this, not the AIG $500 million policy. And then Mr. Hiffa and Mr. Hooray go away, and some Hall Booth lawyer, I forget what his name was, that represents the janitorial company steps in. Or you've got Copeland Stair and Hawkins Parnell stepping in and saying, yeah, we'll take over for everybody because it's on us because we moved the mats. But they messed that up when they didn't go get that video. They're the ones that investigated.
Your Honor, may I respond?
I'm going to give you a chance to respond once Mr. Stoddard is finished.
Okay, well, I'm essentially finished. I can show you the language from Kroger v. Walters, or if you have questions about it, I'm happy to talk more. I do want to add, though, that this is only one portion of the attorney's fees. So we've got punitive damages, bad faith attorney's fees for actual knowledge of the hazard and indifference to it. And then we've got separate from that attorney's fees under this prong, which is the spoliation of evidence. I'm through unless there's questions.
Give me the site to the Kroger case.
Sure, it's 319 Georgia App 52. And I'll pull it up right now while we're talking. So it, see it, Walter sought expenses of litigation. The evidence of spoliation was relevant to the 13611 claim and was properly admitted. The video could have established that Kroger was negligent and knew that it was negligent, yet Walters was forced to file suit in an attempt to establish Kroger's negligence and to spend part of his litigation efforts establishing Kroger's spoliation of evidence. So the trial court was right to admit the evidence for the 13611 claim. So that's what that case talks about. And it's just a second way to get there, right? We're not hanging our hats solely on that. That's just another way to get to the same end on attorney's fees.
All right.
And if I may, and I'll be brief, but I completely disagree with Mr. Stoddard's characterization of this as spoliation of evidence and the applicability of the case that he's citing. This is not spoliation of evidence. AATC does not control the camera systems in the airport. They're controlled by the Department of Aviation. We have no ability to access these cameras. And the emails that were shown by Mr. Stoddard were from Barry Campbell, which is AATC's insurance adjuster, which I would submit is inadmissible on the grounds that it injects insurance into this case. But nonetheless, we acted in good faith. We requested the security footage from the Department of Aviation. There's evidence that we requested the security footage. We sent the requests, and ultimately something happened through the channels where we weren't able to get it and the video wasn't there. There's nothing that we can do about that. We didn't spoil evidence here. We want the security footage. We think the security footage will help our case, and it's a shame that we don't have it, but we didn't spoil the evidence. This is not a spoliation case. And the last thing I want to talk about is, as far as punitive damages and attorney's fees are concerned, about knowledge of the hazard. I still don't see the argument on knowledge of the hazard. I understand what Mr. Stoddard's saying as far as ABM were the ones who stacked the mats, and by virtue of them stacking the mats, they have actual knowledge of the hazard, and this is imputed to AATC. But again, I don't think the evidence is clear, certainly not clear and convincing, that ABM stacked the mats. And also, I don't think that the two stacked mats, just by virtue of stacking them on top of each other, creates a hazard. I think that and also the deposition testimony that he's referring to is all after the fact. It's after the incident where he's asking people if stacked mats can create a hazard. And after the incident, after somebody tripped over the mats, then I think the testimony that it could be a hazard is fair. But I think at the time that the mats were stacked, it was probably not realized that it was a hazard. And I would argue that the two stacked mats on top of each other are not a hazard because the security companies stand on the mats as their standing post. And I would argue that once the security officer steps off of his post and leaves the mats by themselves is then when it could become a hazard. So the act of just alone of ABM stacking, I don't see it as AATC having actual knowledge. In this case, I don't see it as they having constructive knowledge. And again, I said it before, I don't think there's anything in this case that's clear and convincing. We don't know whose mats they are. We don't know who stacked the mats. There's knowledge. There's so many issues in this case that to say that anything is clear and convincing, I think is just wrong.
All right. So on this motion, with regard to the liability, the summary judgment as to the liability claims, the motion for summary judgment is denied. I think there are clear questions of fact as to ownership and or occupier status. I think there are clear issues of fact as to knowledge and existence of a hazard and who had superior knowledge. On the issue of punitive damages, I think there is slight evidence that, at least at this juncture, I can't say for certain that a jury would not be within its purview to award punitive damages based on all the evidence in the record. I am fully prepared to revisit that question on a motion for judgment as a matter of law at the close of the evidence. Again, I think it will depend how and what evidence comes out, but I can't categorically refuse that claim at this juncture of the case. And likewise, for the same reason, and I think I'm focusing more on the idea of proceeding with stacking the mats in the face of a known hazard. There is some slight evidence in the record of that by the janitorial services company, which could be imputed to AATC. So I think the bad faith claim and the punitive damages claim stay on that regard. I am not going to foreclose any claim based on stubborn litigiousness, but on bad faith relating to spoliation, but I'm expressly not denying summary judgment on that ground. And I'm expressly withholding any ruling as to whether evidence of spoliation is admissible at the trial of this case. I've looked only very briefly at the Kroger case which Mr. Stoddard offered. I have some concerns as to whether it's an unwarranted extension of that doctrine in this case, given what Mr. Hiffa has said as the ownership and control of the video in question. I think that's a topic for another day, but I think based on knowledge of the hazard and alleged knowledge of the hazard and the alleged proceeding to recreate the hazard and with the knowledge of the hazard is enough, at least at this juncture, for allowing the bad faith claim and the punitive damages claim to survive, at least through the close of plaintiff's case. That is my order. Any questions or clarifications that y'all need on that?
Would you, Your Honor, one, would you like me to draft something, show it to Mr. Hiffa, and then submit it to you?
Yes, please.
And then secondly, there was also pending a motion for protective order. Is that something that we were going to discuss today, or will that be a separate hearing?
That was not noticed for today, so in all fairness to all the parties, we'll notice that one specifically and we'll have a discussion on that one.
Well, thank you, Your Honor. I'll prepare an order and try to get it over to Mr. Hiffa by the end of the week. And then, we'll see how long it takes to get to you. Sometimes they go back and forth, sometimes they don't.
All right. Well, thank you, Your Honor. Thank you, Matthew. Appreciate it.
All right. Thank you, counsel. Y'all may be excused or you're welcome to stay on for the remainder.
Thank you, Judge.
All right, let's go to, is it Agason or Agosin?
Agason, Your Honor.
Agason versus Regal Custom Homes et al. And we have Regal's and Mr. Bird's motion for summary judgment. So I am ready to hear your argument on that.
Good morning, Your Honor. Adam Appel on behalf of Regal Custom Home and Mr. Bird. And I'm going to talk about our motion for summary judgment. The cases.
I'm sorry, Mr. Appel.
Yes.
Please excuse me. I need to change files real quickly, Judge. I have
Sure.
so they don't merge from case to case.
No problem. Just let me know when you're ready.
Okay, thank you. I'm sorry. Would you please start over? I didn't get any of that.
Let me start over, you said?
Please.
Okay, no problem. Your Honor, good morning. Adam Appel on behalf of defendants Regal Custom Home and Joseph Bird. We filed a motion for summary judgment in this construction defect and breach of warranty case. We have extensively briefed it. There's been a response brief by the plaintiffs, and then we filed a reply brief a few days ago. I'm going to go over the facts fairly briefly. They're pretty straightforward. My client Regal Custom Home is a general contractor. In June of 2016, Trident, who is the developer, contracted with us to build a spec home on 694 East Avenue. Before the home was built, Trident sold the home to the Agasons, and the home was to be built pursuant to plans that were prepared by an architect, not by my client. My client had no involvement in design or planning the construction as far as architectural plans. Mr. Bird and Mr. Russell are the principals of Regal Custom Homes, and they shared responsibility with respect to this project. But what is clear is that they were not the guys swinging the hammers and doing the work. They subcontracted all of their work to various industry trades. We've identified those in the records. In the record, everybody from foundation to finishes were independent contractors. The house was constructed and the Agasons purchased the home from Trident Developers on October 6, 2017. That was the date of the closing. And then after the closing, they had ongoing issues related to including punch list items. And they reported those items. When they had punch list items, they contacted Trident. In fact, they testified that really up until very late in the building process, they thought Trident was the builder of the home. They didn't know that Regal Custom Homes was an entity that was the builder. I assume that's just more of a lack of communication. But in any event, they were not aware of that. But the closing occurred, and then the Agasons moved into the house within a few days thereafter. They subsequently filed an arbitration claim against Trident. I believe that was in March of 2019, and then later filed this lawsuit for construction defects and breach of warranty against Regal Custom Homes, and then later added in individuals, including Mr. Bird and also the principals of Trident. They've alleged defective construction or negligent construction against everybody. And I'm just going to address the claims, obviously, against Regal Custom Homes and Mr. Bird. And then they also alleged a breach of warranty. So let me start out with the negligent construction in our motion. We argued two issues in our motion for summary judgment on the construction defect. Number one is we argued that under general law that we're not responsible for the negligence of our independent contractors. All of these folks that built the homes are essentially, they have skills and qualifications to do their work. Mr. Bird and Mr. Russell don't have those skills. They're not framers. They don't put down hardwood floors. They don't do plumbing, electricity, HVAC. They hire independent contractors. And the undisputed evidence in the case is essentially based on the affidavit of Mr. Bird. He wasn't deposed in the case, but we have an extensive affidavit from him that he went through and said, we didn't control the time, method, and manner of any of these contractors. We didn't tell them what time to show up for work. We didn't tell them what tools to use. We didn't provide them with their tools. We didn't tell them how to do their jobs. None of that stuff. Typical of a independent contractor relationship. They were all 1099. And they did their jobs. The plaintiffs have argued that we are responsible for their work because we were present on the job site. That's one of their arguments, and that we also performed some of the work. Now, with respect to being present on the job site, being present on the job site is not the determinative factor as far as whether or not somebody is an independent contractor or not. The test is whether you control the time, method, and manner. And we cite a case in our initial motion, in our response, Kimball versus BHM Construction, for the proposition that the fact that an employer continuously checks the work of an independent contractor to see that the work is being done according to the specifications of the job is thoroughly consistent with the relationship of employer and independent contractor and the mere right of the employer to insist on a specific result. So it's obviously very common when a general contractor hires various trade folks for them to go out to the job site on a regular basis to make sure that the independent contractors they hired are showing up when they're supposed to. They have to stage, the general contractor will stage the work, tell the folks who are doing the foundation, hey, we're ready for the foundation, we're ready for the framing, we're ready for the electricity, we're ready for the rough end. You know, obviously they need to be there to see what's going on and to stage it. They have the plans. They want to make sure the house is being built correctly. But the fact that they're present on the job site doesn't convert the relationship between the general contractor and the people building the house into a situation where we're vicariously liable for their conduct. And I think that's clear. And the plaintiffs, in response to our motion, didn't attempt to distinguish the case law we cited and didn't set forth any specific evidence of control of the time, method, and manner. They made conclusory statements that we controlled the contractors. Well, I don't know what that means when they just say we controlled it, when the test is controlling the time, method, and manner. There's no evidence from the plaintiffs that we told anybody when to show up for work, how to do their work, what time to be there, what time to leave, any of that stuff. There's no evidence of that. It's just more kind of throw this up, general allegations in order to defeat summary judgment. And that's just not sufficient for summary judgment. They've got to set forth admissible acts, admissible evidence to create a genuine issue of material fact on the issue of time, method, and manner, and they haven't done so. The second argument they made was that Mr. Byrd and Mr. Russell performed the work. Well, they didn't perform the work and they disavow that. But what the plaintiff said, and what's important is when they say that we performed the work, is there were essentially three things that they identified that were done. For example, page 10 of their brief, Ms. Agason, of our brief, Ms. Agason says that she saw Stephen Russell fix a bathroom door. Well, the bathroom door, there's no evidence that bathroom door didn't get fixed. She said she saw him fix it. So if it's fixed, that's not an issue. That's part of the negligent construction, but the door was already there. He didn't install it. He fixed it. She said she saw him install a roof above the office door balcony. There's no evidence that roof above the office door balcony is an ongoing problem with the house. There's no evidence that the work he did was performed negligently. She saw Mr. Byrd perform what she referred to as remedial work on the back deck. Not that he installed the back deck, but he performed some remedial work. So we know that in this case, and it's in the record, that after the house was built, they had complaints about things. He did some remedial work. That doesn't make him responsible for all the other work on the house. And she also said that he installed the kitchen cabinets, which he denied and he didn't. And I want to go into that a little bit more. The Agosons, in fact, resolved their kitchen cabinet warranty claim with Purifest. Purifest, or First, is the entity that actually built and installed those. And exhibit number 11 to the plaintiff's deposition is, it's in the record. I could show it to the court, but I'm giving you the reference to it. It is, in fact, the warranty resolution between Purifest and the plaintiffs with respect to the kitchen cabinets. So number one is Purifest is the designer and installer of those cabinets. Number two, to the extent they had a claim, they've resolved that claim. I suspect that to the extent that Ms. Agason says she saw my client install it and him denying it may be an issue of fact with respect to the kitchen cabinets. But again, they have resolved that claim and there's evidence in the record as to who specifically did design and install those kitchen cabinets.
Let me ask you this question.
Sure.
There seemed to be evidence in the record of Mr. Byrd or folks from Regal Custom Homes doing some things around the house. Tell me, why isn't that at least circumstantial evidence that they were involved in some of the construction? Do they have to have somebody with firsthand knowledge or testimony that I saw Mr. Byrd do this installation that turned out to be defective, which I'm claiming for today? Or can there be more general testimony that, well, they were around and they were doing construction and they were fixing things, so they were involved?
No, that's not sufficient, Your Honor. I mean, when we go to trial in this case, they've got to be able to put up issues of fact, and today's the day that they need to be able to prove that. So just hypothetically, if we were to, let's just say, we take that to the extreme, and my guy, it's true that my guy installed the mailbox, and that's all he did. But he was around there. They said he was around there, he was doing work, but we know it was just the mailbox. And then we go to trial, and they say, we say, well, what did Mr. Byrd do? Tell us specifically what he did. And then the next question is there a problem with that mailbox? And they say no. So now we've got Mr. Byrd sitting at the defense table because they said he did something wrong when we know it was just a mailbox, and the mailbox is perfectly fine. So no, it's not sufficient to just say that he was there, because of course he's there. Of course, Mr. Russell's there. They were the general contractors, and under the case that we cited, the Kimball case, the fact that they're there and supervising to make sure that the work is being done pursuant to the specifications and it is consistent with that relationship of employer independent contractor. And here, the three things that they say that Mr. Byrd and Mr. Russell did are not things, that they was really construction. I mean, to say that they fixed a door or they did remedial work on the deck, they didn't build the deck. They didn't do that work. They may come in and fix things when there's problems as part of the punch list, but that doesn't mean that they're responsible for the entirety of the construction defect. So here, what they've done is they've just kind of thrown everything out there. It's kind of what a defendant may do, throwing stuff against the wall and see if it sticks. You can't do that as the plaintiff. You have a duty to come forward with admissible evidence that we, number one, control the time, method, and manner, which there's absolutely no evidence of. What they said is just we're present on the job site. And I will say that, I mean, I've done construction defect. For a long time, there's always the general contractor is around and telling folks when to be there and, giving them some direction. Here's the plans. I mean, how could they build the house without some direction? Here's the plans. This is when I need you to be there. You don't want the plumber showing up before we're ready for him. So there's no evidence that we did any plumbing work, that we did any hardware installation, that we poured the foundation, that we did the framing. Things that are the problems alleged in this case are not things that Mr. Byrd or Mr. Russell did. And so why would we go to trial and introduce a list of 30 different things we didn't do when they were done by independent contractors when there's no evidence of that? It just is inconsistent with the general law, and it would be inconsistent with what would be expected from a plaintiff in a case who has the burden of proof. So I've put forth the evidence because I knew that was an issue that they said, Mr. Byrd was present, he did some work. In fact, it was after the depositions of the plaintiffs that they amended the complaint to bring in Mr. Byrd to claim he did things. And what he did was elicited through the deposition testimony. Mr. Agason was never there when anybody was doing any work. So it was Mrs. Agason. She said she started showing up really after the framing was done. So anything before framing, she didn't even see anybody do. And then once she did start showing up, it was limited. And I said, what did you see Mr. Byrd do? And those were the things she told us. It's extremely limited. So, it'd be one of those arguments that, if what he did was wrong, I understand he can be held personally responsible for it. But where is the evidence that as of today, what he did wrong hadn't been fixed by him? Because what he's talking about, what the evidence is he was coming in doing remedial work, not that he was there pouring the foundation and the foundation was wrong and never fixed. Let me move on to The next argument, as far as the acceptance doctrine, I'm just going to briefly touch on that. The plaintiff argued that we didn't put forth any evidence of when the acceptance occurred, but Mr. Byrd's affidavit does specifically address in paragraph 12, he says, after construction on the property was completed, Trident accepted the work performed by the various subs, paid RCH for the amount provided for in the contract entered into between RCH and Trident. It makes sense that obviously when the closing occurred, the construction was done and the plaintiffs moved into the house. I mean, that's just clear. I mean, the work was done or they wouldn't have moved into their house. There may have been some punch list items, but that doesn't mean that the work was not accepted.
So tell me, in your experience, how does acceptance occur? When we go back and we want to say, did you accept the work? How do you prove acceptance?
Well, in this case, you prove acceptance by, I'm the general contractor. I've got a customer, Trident, and I go to Trident and I say, hey, we're done. The house is done. It's ready to be delivered to either you, who is our customer. They were going to then deliver it to the Agosins, and they could say, okay, no, it's not done. We're not going to pay you, and we're not going to go sell this house because we've got A, B, and C that's not done that we're not happy with. We have an opportunity to inspect this home. We did inspect it. We walked through the house. We have an opportunity to do that, and we've told you we're good to go. Here's your money, and we accepted it. So the acceptance in a case like this is the two parties who are in a contract have an agreement. I've accepted it. I mean, there may be other contracts, maybe with the state where it's more formal, where they actually issue some form of acceptance. But in the cases I've dealt with in the construction of a home, it's, you know, here we're done, pay me, you know, and we're done. So that's the acceptance here. And it goes further in that the Agosins said, okay, Trident, you know, you've accepted the work from them. We're accepting the work from you. We're buying this house from you. We closed on the property and we took control. The plaintiffs argue that Regal Custom Homes maintained control of the house. That's almost ridiculous. The Agosins moved into the house. They had the keys to the door. They locked the door. We could not just go into the house. When they wanted someone to come back to the house, they called Trident and said, hey, you know, this is wrong. And then Trident would send somebody out there, whether it was Mr. Byrd or whether it was Patrick Vincent, who was another contractor that Trident had asked us to use on the house. Those people were sent out there to do punch list items, or the HVAC person went out there to do punch list items. But the Agosins had to let us in. They controlled the property. We didn't control the property. So in this case, the acceptance occurred when Trident said, you're done. Here's your money. We're going to now sell the house to the Agosins, because what the case law says is that if Trident didn't want to accept the house, they didn't have to. They could have insisted that we do other things to the house before they checked off and paid us and told us we're going to sell the house. But the acceptance doctrine, we don't have to win on the acceptance doctrine for you to grant summary judgment. We have two separate arguments. If we prevail on the independent contractor argument, the acceptance doctrine doesn't really matter today. The other issue is the breach of warranty claim. And there's two arguments with respect to the breach of warranty. Number one is there's no evidence of the terms of the warranty in the record. The plaintiffs argue that it's paragraph 11 of the warranty is applicable that says, except to the extent that the seller is providing no warranty or a different warranty as set forth elsewhere herein, seller hereby warrants. And it goes on and on. But what's more important is the provision in the contract. And if not, if I could share my screen with you.
Go ahead.
Are you seeing the new construction purchase and sale agreement, Your Honor?
Yes.
Okay. So in the new purchase and sale agreement, this is, of course, the contract between Trident and the Agosins. Regal Custom Homes is not a party to this. Under section 11 here, where it says home warranty, says seller shall provide buyer with no construction warranty, the warranty attaches the exhibit, or the warranty described in the home warranty paragraph of this agreement. Well, as you can see here on the executed contract, nothing is checked off. So there's no indication of what specifically is going to be provided. So the plaintiffs have the duty to set forth what the terms are of the warranty that they claim was provided to them by Trident, not by Regal Custom Homes, by Trident, and that Trident claims that they then transferred to the Agusons. So that's issue number one, is the record lacks evidence as to the terms of the contract, of the warranty. And we cite the case of Grossman versus Brown, which I think is very much on point in controlling. In that case, the homeowner sued the actual builder and owner, the person who sold him the house, and in the contract said, we were going to provide you with a 1-year warranty. And they sued under breach of warranty. Trial court granted a motion for summary judgment and argued that the record lacked evidence as to the terms of the warranty agreement. Trial court granted the motion for summary judgment and the Court of Appeals affirmed. The arguments by the plaintiffs were that the purchase agreement makes reference to a 1-year warranty. The defendant argued, but it didn't set forth the specific terms of what the warranty was. And the court said, even though the contract references an intent to create a 1-year warranty, plaintiff did not present evidence that the builder delivered the warranty to the plaintiff, which is what occurred in this case as well. The plaintiffs also argued that, well, the defendant builder in that case the plaintiffs made numerous repair requests during the year following the closing, and the builder attempted to repair those requests on several occasions. But the court rejected the plaintiff's argument that those repair requests and the attempts to repair those items were warranty claims. In fact, the court said those requests referred to punch list items, repair lists, or items that required attention, not warranty claim items. So the court granted summary judgment. Court of Appeals affirmed, saying there's no evidence in the record as to the terms of the warranty, even though the contract references an intent, they weren't delivered, and because the terms are not in the record, we don't know what items were warranted and what were not. Here, we essentially have the same thing. The contract that the Agosons entered with Trident doesn't even set forth which warranty is going to be provided. And then the Agosons say, well, we had this warranty, and eventually after we file the arbitration, we get this warranty book. There's no signed warranty provision by Regal Custom Homes that was transferred to Trident. And Regal Custom Homes said we never provided a specific warranty. So the issue is not whether there's a warranty, but what are the terms? And the plaintiffs have failed to set forth what they are. But the simpler issue is, even assuming there's a warranty, the warranty would require that according to the plaintiffs, the warranty would require they make the claim within a year. And they did not make the claim within a year. They argued in response to our motion for summary judgment that they made the claim within a year to Trident, and that Regal Custom Homes was aware that they made that claim to Trident within a year. But that's inconsistent with the admissions in judicio. The admissions in judicio are that, and it's in their complaint, I believe we cite it, but it's paragraph 29 of the plaintiff's complaint. Plaintiffs state, quote, plaintiffs made a warranty claim on November 29, 2018. You may recall that I said the closing date was October 6th, 2017. So this is a year and a month and a half after the closing that they made the warranty claim. Here is the letter. I've shared the screen. It's exhibit number 26 to one of the plaintiff's depositions. This is the letter they make reference to, that they made the warranty claim on November 29, 2018 via certified mail, Regal Custom Homes. It's in reference to notice of breach of warranty. So the admissions in judicio are that they didn't make the claim within the year. The record, the letter they reference shows that they didn't make the claim within the year. Those are admissions in judicio, which they can't subsequently be denied. The plaintiffs are bound by those admissions, and they admit that they did not make a warranty claim within a year. Your Honor, for those reasons, we urge the court to grant summary judgment as to the negligent construction claim as to Mr. Byrd and as to Regal Custom Home, and as to the breach of warranty claim as to Regal Custom Home. Thank you.
All right. Mr. Hatcher.
Thank you, Your Honor. Judge, as an initial matter, Mr. Appel said something that I think needs to be addressed. First of all, he said at some point that today is the day for the Agusins to prove the facts. I think that is not what he intended to say, but I do want to completely clarify that, of course, that's not the case of summary judgment. Our role is to point to facts in the record that establish a jury question, and I think Your Honor is obviously already onto that. At least with respect to, what the standard of review is. I'm not going to belabor the point, but I do just want to point that out. As an initial matter, one thing that Regal fails to advise the court is that this home is absolutely a disaster. And that's not me talking. That's not my word. That's not hyperbole. That is what a co-defendant in this case has described this house as. They specifically said, an owner of Trident In-Town Developers specifically described this home in speaking with Regal's owners, saying that it is a disaster and that there is a litany of problems that exist. Now, as Mr. Appel already pointed out, at first, Regal's involvement was unclear to the Agusins. They were initially under the impression that Trident was the builder. And in fact, now we obviously know that they were the general contractor, and to avoid responsibility, they make these three arguments, and I'm going to address them in turn, starting with the acceptance doctrine. And really, with respect to the acceptance doctrine, there are two issues for the court to consider. And the first is, when did acceptance occur? Now, you asked, Mr. Appel, how do you prove acceptance? The case of Blondell versus Courtney Station 300 LLC, which was handed down in November of last year, answers that question directly. What the Court of Appeals says in Blondell is that acceptance happens when control is relinquished. Control over the work, control over the property, control over the ability to go back and fix the defects. That is the determining factor. And the court in Blondell does explain pretty well the rationale behind that. And I won't go into detail now. We do recite it pretty heavily in our brief. But one thing I do want to point out in Blondell is that the court found that the contractor was not able to establish when acceptance actually occurred. The contractor has the burden of proof, even at summary judgment, to prove when acceptance occurred. And in Blondell, it just argued in a brief that acceptance occurred at the time the work was completed, when the contractor turned its work over to the premises owner. Now, the Court of Appeals found that was insufficient and said you have to be able to point to a specific fact in the record, some email, some fact, some deposition testimony, something somewhere that actually establishes when that control is handed over. And the court said that just saying they accepted doesn't work. Just like it does not work in that case, it does not work in this case. Another
was actually sold, and that Regal allegedly was actually paid. Doesn't that establish acceptance? Wouldn't there have been some kind of holdback or some kind of notification? Hey, wait a minute, we're not accepting this because of these outstanding issues.
Well, there's two issues in response to that. The first is they say acceptance occurred at closing when Trident accepted the work performed and paid the amount under the contract. The facts in the record show that Trident was still making payments to Regal for work actually being performed on an ongoing basis, even after closing. So if you just take that at face value, that means that Regal was still performing its work after closing. So that does away with it entirely. The second response to that deals with the case, and I'm going to jump ahead a little bit, of Thomaston Acquisition versus Piedmont Construction Group, which is from the Georgia Supreme Court. What that says is it determines when does acceptance occur in a timeline. And what the typical fact pattern is, and what these two cases that I've cited to so far say, is that you look at acceptance not from the subsequent purchaser, but when does acceptance occur from the seller? When does the seller accept the contractor's work? And here there's just no evidence of that. You know, in the typical acceptance fact pattern, you see a owner contracting with a contractor. The contractor does the work. The owner inspects it, and if it's acceptable, accepts it, and then the contractor's done. He's off the job. He moves on to other things. That did not occur here. In the typical fact pattern, where the acceptance doctrine applies, after the contractor's off the job, then the property is sold to a third-party buyer. And then the third-party buyer, under certain circumstances, can be barred as to claims against the contractor. So it's very linear. But here we do not have that. Here we have Regal being involved on an ongoing basis. And, Mr. Appel noted that Ms. Agason specifically saw Regal involved from the time framing was completed, even up to a year after closing. Regal maintains its ability to go onto the property. It keeps going out. There's an open line of communication between the Agasons and Regal where all of these various defects are raised. In fact, 2 days before closing, there's an email to Regal saying, here's this big list of issues. And then we explain in the brief, citing to deposition testimony and other evidence, they're never dealt with. These are defects that exist. They're explained more thoroughly in our expert reports. But Regal has the ability to come out and fix it. It never is able to fix it, though. And then even after closing, that we see that same fact pattern playing out, where Regal is still going onto the property and is still not able to do what it needs to do.
Has Trident, let me ask you this, has Trident or Trident's principals been asked the question, either in connection with this litigation or in the arbitration, have they been asked the question, did you accept?
That there's no fact on record as to that. I've not asked the question. And there's not a single piece of evidence in the record to establish it.
But acceptance doesn't have to be, it doesn't have to be written. It doesn't have to take any particular form. There just has to be some affirmative words or action or documentation that says I accept. Is that your position?
No, my position is there has to be something that the contractor can point to, whatever that may be. Typically, it relates to control based off of what Blondell says. But there has to be something that the contractor can point to say, here is the date on which the owner accepted my work. And they've not been able to do that. The reason that they've not been able.
Completing the closing and paying the contract price is not something that they can point to.
They didn't pay the contract price. There were still payments being made by Trident to Regal after closing.
So so the record shows that they didn't pay the full contract price at the time of the closing?
The record shows that the Regal was still being paid by Trident for work performed by Regal or its subcontractors pursuant to the contract with Trident. The contract with Trident just said, it's very general. It doesn't go into any real specifics. It just says Regal shall build a house. Regal shall be the builder. That's what it specifically says. And it specifically says Regal shall, I want to make sure I quote it correctly. Regal shall perform the work and supply the materials. That's what the contract with Trident says. So it's not like if this was a case where you have a commercial construction job where there's, all of these written change orders and all of that detail that you would expect to see in a case like that, that may be one thing. But in a case like this, it's just a question of, is the work completed? And the answer is the work was not completed. There just happened to be a date on which the property changed ownership and title was transferred to the Agasons. But beyond that, nothing else changed. Regal was still coming out to the property, performing work. It was still hiring subcontractors and directing and controlling those subcontractors. And it was still getting paid by Trident for that work. And so because of that, at the very least, there's a fact question as to when acceptance occurred. And I would say, since they have the burden of proof, and they can't just say acceptance occurred when the work was performed or completed rather, because Blondell had an identical situation and that court said that does not suffice. So I would say because they have the burden of proof and they cannot point to any facts in the record that specifically say, here's when control of the work was handed over to Trident, not to the Agazins, but to Trident. That's what the fact pattern requires in an acceptance doctrine case. Because there's no facts in the record to establish that, they cannot prove that the acceptance doctrine bars the Agazins' claim. Now, I also want to talk about another aspect with respect to the acceptance doctrine deals with, were the defects readily observable upon reasonable inspection? And I cited to the Thomaston case briefly before, but basically what that court says is that the analysis of when of whether the defects were readily observable is tied to the date of acceptance. It's not an analysis of when the plaintiff noticed it, was it readily observable? It's a question of, at the time of acceptance by the original owner, were the defects readily observable? And in this case, because based off of our prior argument, because they cannot establish when acceptance occurred, or because there is at very least a fact question as to when acceptance occurred, they're not able to really prove this exception does not apply. Almost uniformly, moving beyond just the date of acceptance, the types of cases where we see the acceptance doctrine barring claims tends to deal with defects that are open and obvious, not things that you have to do invasive testing for, not things that you have to actually, typically it's things you can just look at and tell there is a problem. We cite to several cases in our brief that support that. I won't go through all of them, but I'll cite a couple. For example, in the Smith versus Dabbs Williams case, it's 287 Georgia App 646. The court found that defects that consisted of a lack of handrails on stairs, that was not a hidden defect, as you could just look at the stairs and tell, hey, that's supposed to have a handrail. It doesn't have a handrail. That's a defect. That's open and obvious. That's something that is readily observable upon reasonable inspection. There's another case, it's the Williams case that we cite to, dealing with the drop off on the shoulder of a roadway, saying that it exceeded the permissible height. Well, you can just look at that and you can tell that's a certain height. That does not comply with the requirements. Therefore, it is readily observable just by looking at it. It's open and obvious. Compare those cases, though, with the David M. Smith case that we cite to, 328 Georgia App 713. In that case, the court was analyzing whether subterranean fill material was improperly compacted, and the court found that there's a fact question there as to whether or not that's readily observable upon reasonable inspection. And that kind of makes sense, because if you have to do invasive testing, like in David M. Smith, if you have to do core samples, is that a reasonable inspection? And of course, anytime we hear reasonable, we tend to think fact question, but that's besides the point. Compare those cases to our case. Here we have, we hired an expert named Sam Creech to come out and do invasive testing on the property. He actually came out multiple times. The first time he came out, he just looked at everything, did not perform any invasive work, and was able to outline some of the resulting damages. So for example, we have water intrusion on the main floor, and it's causing the floors to cup. He was able to analyze those things, but he was not able to analyze the cause. In order to do that, he had to come back out another time to actually perform invasive testing and determine what the cause was. So for example, we have flashing in the doors that were not it was not installed properly. That's led to water intrusion. We have a TPO membrane that has has depressed open gaps and a negative pitch, that he had to do invasive testing to determine that. There's other flashing and caulking type defects that exist and deficiencies that exist throughout the house that he details in his report that we attached to our brief, that explains that in order to, discover these defects, he actually had to perform invasive testing. Because he had to perform this invasive testing, it's not readily observable upon reasonable inspection. And it certainly was not readily observable at the time of, quote, acceptance, even if we do give Regal the benefit of the doubt that acceptance occurred at closing. Another reason for that is Trident's own deposition testimony. When we deposed the owners of Trident's, we asked them at the time of closing, did these defects exist? They said, and I'll list a couple examples. Now there's a third floor terrace. It does not drain properly. Their testimony was that at the time of closing, it did drain properly. So if we're going to believe what Trident says, which for purposes of summary judgment, we have to, then, that's a defect that did not exist at the time. It was not readily observable at the time of closing. Same thing with the dip in a master bedroom floor. There's now currently a dip in the floor. Trident said that did not exist at the time of closing, so therefore it would not be readily observable upon reasonable inspection. And so to wrap up that section, and I'm happy to answer any other questions you have about it, Regal has the burden of proof. They're not able to establish when acceptance actually occurred. This is not the type of fact pattern that you see the acceptance doctrine being applied in, because there's no clear date when the control is relinquished from Regal to Trident. Instead, Trident just sells the house to the Agasons, and then Regal remains involved. And because of that, the acceptance doctrine just does not apply. So I'm happy to answer any questions you have, but I can also move on to the next issue. So the next thing I will address is the warranty claim. And there was a case that Mr. Appel cites to Grossman versus Brown. And you can differentiate that case slightly. And I want to explain why in my argument. Really, it comes down to an issue of contract interpretation. Based off of the fact that box is not checked on the new home purchase and sale agreement, there's a question as to what did the parties intend with respect to a warranty, because I believe there is an option that says none is being provided. We can look, when you have a situation where the contract is vague, you then go to the rules of construction, the statutory rules of construction, to interpreting the contract. If that does not show what the party's intent is, then you look at parole evidence. And the parole evidence in this case certainly indicates that there was a warranty that was provided. Now, I do want to note, it's very interesting that Regal essentially takes the position, we didn't provide a warranty. By saying that, they're admitting to violating Georgia law. There is a statute, OCGA 43-41-7, that specifically says that a residential contractor shall offer a written warranty when they build a home like this. Shall offer it. It's not might, not may, not, it depends. They have to offer it. So if we're taking them at face value, they're admitting to violating that statute and violating Georgia law. The parole evidence, though, that I was referencing a minute ago does suggest, though, that a warranty was provided. When we deposed Trident, again, I asked them about that paragraph in the purchase and sale agreement and said, was this warranty provided? And they said, yes, Regal provided it to us and we provided it to the Agasons. So we have testimony, we have facts on record that establish a warranty was provided. Now, the question is, and what I think Mr. Appel is really trying to get to, is what are the terms of the warranty? And that's really spelled out in the warranty book that we've referenced in the brief and that we've already talked about briefly. And there the timeline becomes important again. Under the purchase and sale agreement, the Agasons did have 1 year to actually make the warranty claim, but they were not given the warranty standards. They didn't have the applicable standards that the builder had to comply with to be able to say, all right, here's the standard, here's where they violated the standard. In fact, what the emails say, and we cited these in our brief, is that Regal did not even order the warranty book setting forth the standards until July of 2018. So those standards weren't even purchased yet. Then after Regal finally purchases it, they never turn them over to the Agasons. So, and as Mr. Appel referenced, we did not even get those until we file an arbitration against Trident and we get into discovery with Trident. So we don't know what the warranty terms were until much later. We obviously do now, but at the time we were going off of the fact that we're under the impression, based off of representations from Trident, that Trident was the builder. Trident was the one that said they're going to provide us a warranty. Trident's the one that ultimately did give us the warranty terms, the warranty book setting forth the standards. And we absolutely did send a demand to them within the time period. And more importantly, and this is kind of a substance over form analysis, but Regal was undoubtedly on notice. I mean, it's undisputed they were on notice of the fact that the Agasons were making a warranty demand. We know that because when we send the Right to Repair Act demand to Trident, and also we included a demand for warranty in that letter, for breach of warranty in that letter, we then have emails that were produced later between the defendants, between Trident and Regal, where they're talking about those claims. So they were on notice. It's just a question of, were we even able to comply with the warranty procedures that they're now wanting us to hold to, while simultaneously not giving us the warranty standards for us to actually be able to analyze. And so our argument, Judge, is that based off of all of that, first of all, a warranty obviously exists. At the very least, there's a fact question as to that. Second of all, a jury could certainly find that under these circumstances, given the fact that Regal was late on actually ordering the standards and never delivered the standards to us, a fact question exists as to whether or not we were able to comply with the warranty procedures and whether we did, to the best of our ability. And also, were they on notice? They were absolutely on notice. And therefore, this is something that a jury should be able to at least determine. The last thing I'll talk about is what was Regal's actual responsibility on the project.
Before you move to the next point.
Sure.
I hear you, and I'm sympathetic to the point that there was, at least on this record, some confusion as to who was responsible for the warranty, what was in it, and when it was provided, so that it would be unfair, right? I think the argument is it's unfair to hold them to this strict 1 year from the date of closing as against Regal. But the warranty says what it says. So what's the legal basis, right? What's the legal basis for me to say, okay, you didn't have to comply with that? I can't just say, well, it's just not fair and they were confused. There has to be some legal theory for me to say, okay, you're excused from complying with that 1 year rule, or that 1 year doesn't apply because of X. And at this point, I'm not sure what that basis would be, other than for me to say, I just don't think it's fair to apply it.
It's waiver and estoppel. So they have an obligation to comply with, number one, their statutory obligations. They have an obligation under Georgia law to provide a warranty. Number two, under the contract, at least Trident had an obligation to provide a warranty, and that warranty was valid for 1 year. Based off of the record, Trident actually ordered the warranty book on behalf of Regal. That's technically what happened. But Regal was the one that was, quote, supplying and honoring the warranty, is what the facts have actually turned out to be. And so Regal does provide that. We don't get it until much later. And by not providing a warranty at the time of closing, like they're supposed to do under Georgia law, under that statute, then there's a very good argument that they've waived the right to say, well, we were late, but it's not okay for you to be late. they've waived that argument and they're stopped from arguing to the contrary. So I think that is that is the legal basis to say it's not fair.
I'm going to ask you to do some more research in that and see if you could give me some case law to support that proposition.
I'll be happy to.
I'm sympathetic to that argument. I want to be clear that I'm on all fours legally in applying it in this case.
And I'll be happy to do that, Judge. And just elaborating on it a little bit further, I think that's going to, again, get really into just general rules of contract law, right? So you can waive even a, no waiver provision in a contract. There's all sorts of things that can be waived by your conduct and by the circumstances. There's express and implied waiver, just like there's express and implied ratification, like I'll get to in a minute. And so we can look at the conduct or the lack of action on behalf of Regal and use that to say, they've waived their right to hold us to the four corners of the document. But I'll be happy to brief the issue for Your Honor.
All right.
The last issue I want to talk about is what was Regal actually doing on the property. And there's really three basic principles that we need to keep in mind. Number one, if you perform negligent construction, you can be found liable. So, that's just the entire purpose of a negligent construction cause of action. Number two, if you are a member of a company which performed negligent construction, you can be held individually liable if you were actually participating in or directing or controlling the work. That's based off of a piercing the corporate veil type analysis. And we cited the Sun Nurseries case in our brief to support that. The third principle that I want to keep in mind is that if you hire a subcontractor to perform work and he does so negligently, you can be liable for the subcontractor's work if you ratify it. And so keeping all of that in mind, I want to spend a little bit of time on what the facts are in the record, because I think they were breezed over a bit too quickly in defendant's argument. There is a significant amount of testimony from Mrs. Agason that we actually placed directly into the brief that detail what she saw. They want to say, oh, she was there only some of the time, she doesn't remember some things. That's all fact questions. That's all things that a jury should decide. There are facts on record that she testifies to that she specifically saw these individuals, these owners of of Regal, actually being on the property performing work. So for example, Mr. Creech in his report details the problems with the back deck. There's a number of defects that exist with the back deck. She specifically testified in her deposition that she saw the owners of Regal performing work on the back deck. Now, if it was actually just constructing it or remedial work, that's something that, we probably disagree on. And there's facts in the record where, like Your Honor was saying before, certainly inferences can be drawn, and at summary judgment, those inferences are to be given in our favor as the non-movement. But there are facts on record showing they were actually doing work. There's also a significant amount of testimony from both Mrs. Agason and the owners of Trident that the owners of Regal were actively directing and supervising and controlling the work. Now, Mr. Appel keeps making reference to time, method, and manner. That's not the standard for determining whether someone is vicariously liable. That's the standard for determining whether you're an independent contractor or an employee. That has nothing to do with this case. We're not contending that any of Regal's subs were employees. Of course they're not. This is construction. That's not how it works. These were subcontractors. And what happened was there's testimony unequivocally that they were actively controlling the work, directing the work, supervising the work. For example, with respect to the windows and doors, Mrs. Agason specifically testified that she saw Mr. Bird directing the installation of all of the doors. Well, all of the doors are a significant problem in the house because that's a significant source of water intrusion into the house. This led to all of the damages that we outlined in the Stan Garnett report. So there is evidence in the record that they were actively controlling the work and were involved. There is some evidence that they were performing the work. And as Your Honor has previously noted, even slight evidence is sufficient to survive summary judgment. And so that argument fails. Furthermore, there's evidence of ratification. And I think that the law on ratification is breezed over a bit by the defendants. And so I do want to spend a little bit of time on that as well. But we begin with the idea that whether ratification occurred is typically a fact question for the jury to decide. That's the Medley versus Boomshire Pontiac GMC case, 214 Georgia App 795. And really, this is based off of statute OCGA 51-2-5-6, which says that an employer can be found liable for his contractor's negligence if he ratifies it. What the case law says is that ratification can occur in a number of ways. Obviously, there can be express ratification, or it can be implied from one of three things: either slight acts of confirmation by Regal, silence or acquiescence by Regal, or whether Regal received a benefit from the unauthorized wrong. And there are facts in the record that support at least two, possibly three of these implied situations for ratification. For example, if Regal is actually there performing the work, if it is actually supervising these contractors and then reaping the benefits of it, there is an argument that they are acquiescing to the work, that they are consenting to the work. There is also, by receiving a significant sum of money for this property that only could have been built with the help of the subcontractors that perform negligent construction, they're receiving and retaining a benefit from the work. The documents that Regal provided us show they received upwards of $300,000 on this job. And it's all because of the negligent work that was performed. The subs did perform negligently, but they also did some things that were non-negligent. So for example, the house hasn't fallen down, right? So, I mean, they did deliver some product. It is defectively delivered, and there are some serious problems that we've outlined in the brief, but because they were able to deliver it with the assistance of their subcontractors, even with these unauthorized wrongs, even with all of these defects, Regal still reaps the benefits and retains almost $300,000 worth of proceeds from Trident for that. So those are facts that a jury can rely upon to find that there's been an implied ratification. That's something that a jury has to be able to decide, and therefore summary judgment is inappropriate as to that as well. And I'll just wrap by saying this, and again, if you have any questions, I'm happy to answer any that you have, but this is, there's a reason we didn't move for summary judgment. The work, it's undisputed, the work is horribly done. Nobody's here saying that there aren't problems, but there are several fact questions that do preclude summary judgment really from either side, including when was the work actually, finished, when, whether there was a ratification, how the warranty situation worked out. Those are things that there are jury questions, there are competing factual inquiries that a jury would need to decide. And so therefore, summary judgment is just inappropriate in this case.
Let me ask you this on a separate issue. Regal and Mr. Byrd did move on your claim for attorney's fees. I don't see that you addressed that in your response brief. Maybe I just missed it.
Judge, I believe that.
Do you want to address it now?
Yes, I do. And if I didn't address it, I meant to address it, and I can certainly address it now. As a general rule, claims for attorney's fees are completely ancillary. So if you're not able to survive, or if there's a fact question as to the underlying claims, typically there's going to be a fact question as to the claims for attorney's fees. And obviously there are several different ways to get 13(6)(11) fees: if there's bad faith, if there's stubborn litigiousness, or if if the defendant has caused unnecessary trouble and expense. The fact that it is undisputed that the work is so egregiously bad The fact that we put them on notice, that even before the lawyers got involved, Miss Agason was talking directly with Regal saying, hey, these are problems that need to be fixed. And nobody seems to dispute that these are problems that need to be fixed, yet they're never fixed. I think that's evidence that a jury could rely on to say this is evidence at the very least of causing unnecessary trouble and expense. It's probably something that the jury could consider for bad faith. But you know, that's really the factual basis, is the fact that the work was so bad, they had an opportunity to go out and fix it. Quite frankly, they tried, but then they stopped trying once they were unable to fix it. And then with a lot of these things, they didn't even try. So for example, we have, we've got the issue with the cupping floors. We've got the issue with the water leaks. We've got issues with, drywall cracking up the stairs. We have all of these issues that were never even addressed. And if we do detail that in the brief of specifically with respect to the email that was sent 2 days before closing, with the I think it's a 3-page list of things that need to be addressed. We then spend a dozen pages after that citing deposition testimony of how they never even tried to fix those. So I would say that's bad faith. That is causing unnecessary trouble and expense, because quite frankly, we shouldn't have to go through this process. We shouldn't have had to file suit because it was so undisputed that the work was so bad, and they're just trying to hide the ball, really. So that's my argument with that. If Your Honor would like me to brief that further, I certainly can. I appreciate you bringing it up, but I'll leave it to the court on that.
I don't think there needs to be a separate briefing on that issue. So I will excuse you for now and let Mr. Appel have the last word to the extent he wants.
Thank you, Your Honor. I do have a few things I would like to address. Number one is with respect to the acceptance argument. Again, though, I will say I don't think the court needs to get to the acceptance argument, but I do want to address it because it is important. Mr. Hatcher says that we've got to come forward with more evidence of acceptance. And you asked a very poignant question. And one of those questions was Trident asked about whether or not they had accepted the work. And as he said, he didn't ask that. He did depose the principals of Trident. That question wasn't asked. However, Mr. Byrd does address that issue. And as I mentioned in his affidavit testimony, he specifically says, paragraph number 12, affidavit testimony in the record, it's undisputed. Trident accepted the work performed and paid RCH for the amount provided in the contract. So there is evidence of acceptance. Then we know that the Agosons closed on the house and moved in. And Mr. Hatcher seems to argue that even though the Agosons owned the property, had the keys to the door, that somehow Regal Custom Homes still maintained the ability to control and go in and do work. There's evidence in the record that they made a complaint or made a request for some work to be done. And Ms. Agason said, absolutely not. It's the holidays, that time frame. You are not coming in my house. If that doesn't show that she exercised dominion and control over her house, nothing else does. We were not free to go to that house and continue doing work. Number one, clearly the Agosons had control of the house. We did not have control. Had we gone to the house and tried to walk into her house and do work, pretty sure the cops would have been called. Number two, the issue with respect to
here's where I'm getting off track in trying to follow the logic.
Okay.
First, we've got Mr. Byrd saying it's acceptance, but isn't Trident the party that has to accept? With no testimony, all Mr. Byrd can say is, well, I think they accepted, because there's no affirmative statement by Trident that they accepted. And what I'm seeing from the record is Regal knows it still has some obligations to Trident, and Trident is trying to still hold them to these obligations. And that's why they're continuing to be, why Regal's continuing to be engaged in trying to fix some of these problem areas that the Gosens are complaining about. So I'm finding it much, I'm not finding Mr. Byrd's affidavit conclusive and convincing as to that. Somebody needed to go to Trident or show me something where Trident says, yeah, we accepted. Yeah, I can point to you and I said, yeah, well, I say that they accepted, but are you really confident to say that they accepted without some evidence from them in the record that they say, yes, we accept?
I hear what you're saying, Your Honor. However, the plaintiffs could have elicited that evidence and they didn't.
But the acceptance doctrine is a defense, right? Isn't that an affirmative defense?
It is a defense, but I understand you're not convinced by Mr. Byrd's affidavit, but there's two parties to a contract. There's Regal Custom Homes and Trident. And if the parties are not in a disagreement about whether or not there was acceptance, then there can be some evidence about it. But here, there's not that evidence of disagreement. And the fact that Regal Custom Homes continued, that kind of rolls into the warranty issue is, that they were being called for punch list items. And so, of course, they had the obligation, if there's a warranty, to continue going into the house. And I know that gets into the warranty issue, but the fact that they were going back to the house and doing work doesn't mean there wasn't acceptance. And in fact, Trident could have said beforehand, they could have said, we're not going to accept the work. We're not going to pay you for the work, and we're not going to sell it to the subsequent purchaser if we don't accept it. I wanted to go to another point that Mr. Hatcher mentioned. He said that there was ongoing payment. So if that was the argument, if there was ongoing payment, and because of that ongoing payment, there wasn't acceptance until the payment was done, page 13 of their brief is where they talk about the ongoing payment. And the ongoing payment, some of it's punch labor. They've got a table in their brief, but it shows paint materials and permits. It's just a document. It shows date, expense, and detail. But the point of it is the dates that they list are October 6th, which was the closing date, and then the 10th, 11th, 12th, 13th, 16th through this October 16th, which was touch-up paint labor. So to the extent there wasn't payment until then, the payments were completed as of October 16, 2017, according to the plaintiff's own brief. So if those in fact are items that were part of the contract, and I don't think they are, I think they were additional items that were paid for, because it says punch labor. So there was additional things that Trident said, hey, you need to do this work, and then they paid us to do that work. I believe it was above the contract price. But anyway, that October 16th. So if payment is the issue with respect to acceptance, then certainly by October 16th, after the closing, after the Gosens moved in, after all the payments were made, would certainly indicate the acceptance, along with the affidavit testimony of Mr. Byrd. So let me move on to another issue with respect to what Mr. Hatcher argued, was with respect to the warranty issue. And, for the first time we're hearing, based on the response to your question, this waiver and estoppel. Well, their argument, first of all, they're bound by the arguments they made in their brief and in the complaint. And they argue that the warranty is set forth in the purchase and sale agreement that they knew about when they signed the purchase sale agreement. And I'm going to share again my screen. They argue, and it's also in their brief, they make reference to paragraph 11, home warranty. And they say, this is the applicable warranty. This is what they're arguing was applicable to them. They say, and it says, except to the extent seller is providing no warranty or a different warranty as set forth elsewhere, Seller warrants the improvements on the property to be free of defects and labor and materials, excluding defects caused by the vandalism or acts or omissions of the buyer and those under the control of the buyer for 1 year, for a 1 year period commencing from the date of the closing. So to the extent they are arguing they didn't know the terms of the contract, that's not actually true. They knew about this 1 year warranty when they signed this contract with Trident. They knew of the obligation to make the warranty claim in 1 year, and their admissions in judicio are that they made the warranty claim to Regal Custom Homes more than a year afterwards. They're bound by those facts. That's not a fact that they can come in and now argue waiver and estoppel. The contract says 1 year. They made the warranty claim 13 months afterwards. That claim is precluded. There's no waiver that occurred based on them not knowing the terms. They're the ones who are arguing that that's the term of the contract. We contend that the terms are not set forth and therefore they can't even prove a breach of warranty. But if they want to claim breach of warranty based on that term, they knew it was 1 year, and it'd be disingenuous to argue waiver and estoppel at this point. The last argument I want to address is the issue of control and ratification. So Mr. Hatcher said that the test about vicarious liability isn't time, method, and manner, but that is the exact test. The fact that the contractor is out on the job site is certainly consistent with these folks being independent contractors. The actual test to determine whether or not we can be vicariously liable for their conduct is time, method, and manner. We're not liable just because we're out there at the job site. We're present and telling people when to, from staging purposes, the plumber needs to be out here at this point, and we're out there when the windows are being installed and giving some direction. Mr. Byrd has set forth, he didn't tell the people what time, what materials, when to be there, how to do their job, and that's unrefuted. Just seeing somebody out there, that's not sufficient to create an issue of fact. And when I said they have to prove their case, what I mean is they have to prove issues of fact exist with respect to each contractor. So would it be fair to go to trial if, for example, we directed, and hypothetically, we directed one contractor, let's just say the roofer, how to do his job, told him what time to be there. We directed everything about that job. But with respect to all the other subcontractors, we didn't say a word to them other than, we want you to do this work. And now we're going to go to trial, and they're going to put into evidence that the plumbing's wrong, that the HVAC is wrong, that the foundation's wrong, the landscaping, when all that was done by subcontractors. They had the opportunity to bring in these subcontractors. We identified them in discovery. We did a notice of non-party fault as to the subcontractors. They made a conscious decision not to sue the independent contractors who did the work. They could have done that, and they chose not to do that. And it doesn't turn around and make us responsible for all of the work done by these subcontractors. They don't just get to throw up mush and just say, we were there, and therefore they're responsible for all the work. With respect to the ratification argument, the ratification argument requires that we have knowledge, actual knowledge of these defects in order to ratify it. Otherwise, it would turn the statute with respect to not being responsible for your independent contractors. It would just abrogate it. Every case of a general contractor, they always hire subcontractors. They always make money off of them. So they're always going to benefit. Just the fact that a subcontractor did some work that turns out to have been negligent down the line doesn't mean you ratified the work. You had to have knowledge. And that's what we say. We cite a case in our reply brief for the with respect to the ratification issue, that there has to be knowledge. It can't simply be that work was done and that you didn't do anything about it. It's more than simply, we hired a contractor, the contractor did the work wrong, you benefited from it, or you somehow acquiesced. There's no evidence that we knew contractors like the HVAC contractor. We're not HVAC contractors ourselves, so there's no way we would have known if they did something wrong. We can't inspect their work and determine that they did something wrong. And had we done that, inspected it and knew they did something wrong, we would have told them to fix it, but there's no evidence of that. So to prove that we acquiesced in all of the negligent work is simply not in the record. They failed to show that we have ratified the negligent work, that we had knowledge of that. So in short, Your Honor, I would say that we are not responsible for the independent contractors. To the extent Your Honor thinks there is an issue of fact with respect to work we did, then the court should specifically say, well, if the work that was done, if we've identified it in our motion, the remedial work on the deck, the fixing the door, and I think the roof issue with respect to Mr. Russell, if those are things that the plaintiff has created an issue of fact on, then that would be the only issue to go to the jury. Were those issues negligently constructed? But there's not evidence in the record that those issues remain as of this day. That's simply not in evidence. So with respect to the motion for summary judgment on negligent construction, I would ask the court to enter summary judgment. And with respect to breach of warranty, I would ask the court to enter summary judgment based on the lack of evidence of the terms and on the admissions in judicio that they did not make a claim within a year from when the closing occurred. Thank you, Ron.
All right. I do want to hear some more on the breach of warranty claim. I'm going to reserve ruling on the other claim, the claim for negligent construction. I'm also going to reserve ruling on the 13-611. I will tell you though that my general leaning is that I'm leaning towards denying the motion for summary judgment as to the negligent construction claim. I think my first impression is that there are enough facts in the record to get it to the jury. On the breach of warranty, again, I'm withholding. I want to hear argument on the waiver and estoppel argument, and certainly Mr. Appel, you can have an opportunity to respond to that. I'm going to give you 15 business days, Mr. Hatcher, to submit any supplemental authority on the warranty issue. And then Mr. Appel, I'll give you another 15 business days after that to respond to any additional arguments on that issue. I don't see on the 13-611 claim, my inclination as I sit here is to grant the motion on the 13-611. I am reserving ruling, but that's my leaning. I see continuing issues with quality of construction. I see continued efforts at remediation, and there's some evidence that eventually stopped and said, we're not going to do this anymore. There's issues in the record as to how the responsibility should be divided, as to Trident and as to Regal. Just our argument here today suggests numerous contractual and legal issues dealing with ultimate responsibility. There are just too many issues of fact or liability for me to say that there's stubborn litigiousness and I only see, if there is any evidence, I only see evidence of negligence, not evidence that we were recklessly and intentionally trying to harm the Agassins. I don't see any aggravating factors in the record, so that's where I'm leaning on 13-611. I'm going to wait for and look at the briefings on the remaining issue, and then we'll talk about a final order on those claims. But my expectation is that at least some claim is going to survive summary judgment here.
Thank you, Your Honor.
Thank you, Your Honor.
All right.
Thank you, Your Honor.
Y'all may be released. I think I have somebody waiting in my waiting room. We'll address that issue separately so everyone else can be excused. Ms. Winfrey, if you would stay on, I may want to put this on the record.
Thank you, Judge.
All right.
Judge, give me 2 seconds to change files.
Came on about 10:30.
Thank you, Judge. Ready.
Good morning, Mr. Alexander.
Hello, Your Honor. I've been trying to sign in since like about 10:30 this morning. I couldn't find the Zoom information. I did find an email from a lawyer from another case that it sent an email to Trinity Townsend, I believe her last name is. I found that about 10:30, and it had an ID. It had an ID, meeting ID. So I put in that meeting ID, and I guess it's been open. Actually, I was doing something else. I'm sure I'm as surprised to see you as I'm sure you are to see me. We had not gotten the Zoom information, and Mr. Boyd had actually sent an email to Ms. Townsend requesting the sign-in information. I was included in that email, and so I was waiting to get it. And then this morning when we were trying to sign in, we still didn't have it. So I then called Ms. Townsend's office and left a voicemail. And I don't know what's happened. So this actually is just still open from where I did find that the email from that other lawyer. I can look that up and give you who that was. And so I just trying to do what I could do, I then put in that ID, but it never allowed me in. It just kept saying that I'll be invited in at some point. So you're probably preparing for some other matter.
Well, I'm actually just concluding this hearing that I had set, which obviously your case was noticed. And I will say that, Mr. Townsend sent out notice of this hearing and Zoom information on this hearing, and every attorney but you signed in successfully and on time at 10 o'clock. I can't speak to what you received specifically or didn't receive, but by 10:30, and you were not on, and you did not come on in the time that we were dealing with your case. I called the case and at approximately 10:30, you were not on, and you not having appeared on your motion to reconsider my ruling, that motion was denied. So the next step is there is currently a pending motion for attorney's fees under 915-14 that was filed by Bell South we're going to set a hearing on that motion. I understand you've already filed a response to it, but there'll be a hearing and you'll have an opportunity to question Bell South witnesses if you wish to do so, or present whatever other evidence you want to in opposition to the motion for attorney's fees. And then we'll deal with that at that time. Now, I will tell you, this is likely going to be a virtual hearing, and you're going to get notice the same way you got the notice for this one. So just be sure well in advance of the time that hearing started that you can sign on and you have that information so that you don't miss your opportunity to present the arguments that you need to present.
Yes, Your Honor, I hear you. All I'm telling you, just like we're having this connection at this time, you know, this is because I actually did sign in. It was right after 10:30. It's under the circumstance that I've stated to the court. I'll file a motion and as for the court's consideration based on, really, I had no way. I did not get the Zoom information, and Ms. Townsend, you know, if she checks her voicemail, she'll see I called before the hearing got started, informing that I had not received that information, and also I did not see a response to Mr. Boyd's email to her requesting it. But I hear the court. I'm just telling you what's happened, and I'll file a motion to bring it before the court for your consideration.
All right, we'll look for your motion and we'll take it from there.
Bless you.
All right.
Bye now.
All right, thank you, Ms. Winfrey.